Welcome to today's webinar. As a global consulting firm, Protivity is here to help you connect, grow, succeed. We invite you to visit us online at protivity.com/webinars to find other great content and subscribe. Now, let's begin.
Welcome, everybody, and thank you for joining us today for the next webinar in our Value of Compliance webinar series, Warning More Change Ahead, Perspectives on an Increasingly Dynamic Consumer Compliance Landscape. We're so glad you're here, and we hope you'll find the material meaningful and insightful. Before we begin, I'd like to go over a few housekeeping items. Firstly, today's webinar is being recorded and will be available on demand. Please be sure that you're using Chrome or Microsoft Edge for your browser, as older versions of Internet Explorer or Safari are not currently supported. Audio should be streaming through your computer, but if you have any technical issues, feel free to drop us a message in the Q&A box. And also throughout the conversation today, please feel free to enter your questions there as well for our presenters. We will reserve time at the end of our conversation to answer those, and we'll try to address some of those in real time as it makes sense. So with that, let's jump in with a few quick introductions. I'll introduce myself first. My name is Tom Giltro. I'm a managing director and the leader of Protivity's compliance practice. Really excited to be here today to moderate today's panel. I've spent the entirety of my career here with Protivity helping our clients navigate regulatory challenges across all three lines of defense, where I personally specialize in compliance program design and consumer compliance. Incredibly excited as well to introduce our three panelists that are joining me today. First, we have Joaquin Rodriguez. Joaquin is the director of Protivity's risk and compliance practice, where he supports clients in addressing regulatory matters related to risk management, regulatory compliance, and technology. Prior to joining Protivity, Joaquin spent 10 years working at federal regulatory bodies, including 6 with the CFPB. And while there, Joaquin served as the examiner in charge for both bank and non-bank financial institutions and large technology service providers. He also helped to represent the CFPB in various FFIEC IT working group forums and helped to support the development of the Bureau's capabilities to examine technology service providers. We're also joined by Kimberly Morris. Kimberly is an associate director in Protivity's risk and compliance practice. She has 19 years of experience in banking and regulatory compliance, including in industry as the CRA and fair lending officer of a mid-sized national bank, and with us at Protivity in consulting with projects supporting all three lines of defense. Her experience and expertise includes consumer compliance, compliance program development, regulatory remediation, and fair and responsible banking. And then very pleased to have Josh Coden, a partner in Cooley's Chicago office, joining us today. Josh represents banks, non-bank lenders, fintech companies, and other financial services providers with significant enforcement matters before a host of federal and state regulatory agencies, including the U.S. Department of Justice, the Consumer Financial Protection Bureau, the Federal Trade Commission, and the U.S. Department of Housing and Urban Development. Josh handles investigations pertaining to a range of consumer financial products, but with a particularly strong specialty related to mortgage lending, servicing, and deposit operations. So that I'd like to say, welcome to our panelists. Thank you for taking the time to join us today, and really excited to dive into the discussion. We have a lot to get into, and 2024 has been an eventful and exciting year, and there's a lot to look forward to in 2025. For our audience, just briefly for the agenda today, we'll have a moderated panelist discussion. We're going to start by talking about matters that are relevant to kind of 2024 year to date. So we're going to spend a little bit of time looking backwards before we look forward. What we learned from some of the supervisory guidance, new laws and regulations, enforcement activity, et cetera. We'll talk about some of the current regulatory changes on the horizon, emerging consumer compliance hot topics and priorities. And then lastly, we'll shift into looking ahead to 2025 with a discussion around what some of the Supreme Court actions recently mean for the regulatory landscape, as well as what the U.S. presidential election may hold for supervisory priorities as we look into 2025. So with that, we'd like to start with a brief audience polling question. So please take a moment to open up your screens and vote on this question. So our ask to you is, how would you characterize consumer compliance regulatory scrutiny and enforcement in 2024 to date? Significantly heightened, moderately increased, consistent with prior years, or somewhat lessened? So we'll give everyone a moment to submit their responses. Thanks for your participation. This is always a fun part for us to see how our audience views priorities in the regulatory landscape and tailor some of our commentary as we go through the presentation. While we're collecting responses, I'll also just note that you can find additional resources as well in the resources pane within this webinar. Feel free to explore at your leisure during the conversation today. And following, we have links to a number of pieces of thought leadership, links to our Voice of Compliance webinar series and relevant podcasts as well. So it looks like we are just about at a good response rate. So we're gonna see how you all responded. So great to see that I'm not way off base in my own feeling and some of the anecdotes that we've gotten from our client contacts. 2024 at least certainly is felt to a lot of our clients as one that's been characterized by heightened scrutiny. What I thought was interesting in kind of looking at some of the statistics coming into today, we're at about the same number of enforcement actions from the CFPB as we were this time last year. But I think there's still a very prevalent feeling that supervisory scrutiny, that regulatory expectations are continuing to shift and grow, and certainly see that reflected in your responses. 51% significantly heightened, 35% moderately increased, only 10% consistent with prior year, and 1% somewhat lessened. So thanks for your input on that. Certainly interesting results from our perspective, and I think consistent with what we've heard from many of our clients. So what I'd like to do now is open it up to our panelist discussion. We're going to run through a few different questions, but as I mentioned at the top of the call, really want to start with reflecting a bit on 2024 today. So kind of as we look at the many actions, some of the shifting supervisory priorities, and what can we learn? So we're certainly not turning the page on 2024 just yet. It's been an eventful one. But if we take a moment to look backwards on what we've learned from the year, Joaquin, I'll start with you. I'm interested in your perspectives on where supervisory priorities have been this year. Can you tell us a bit about what you've seen in terms of increased focus from the regulators in consumer compliance? And are there any emerging hot topics or trends that you've seen?
Sure. Thanks, Tom, and appreciate the opportunity here. So we really have seen a pretty packed regulatory agenda this year, and we've seen the regulatory bodies, especially the CFPB, really focused on a number of consumer compliance related activities. So, one of the things that has continued is the war on consumer fees. So the heightened focus on the different types of consumer fees applied to customers. And I think that, what's been particularly interesting is how the Bureau has expanded this beyond our traditional retail bank fees. And we're seeing a lot of activity in other areas where the CFPB is applying its view on, what are deemed to be junk fees or unnecessary fees. Those things span things like, solar energy loans and credit repair, and even, very recently, a lot of focus on school lunch account transaction fees. So we're really seeing, a lot of emphasis in that area and an expansion into non-traditional areas where we wouldn't otherwise expect, regulatory bodies to be probing into when it comes to some of these matters. Also, consumer reporting continues to be a hot area. One thing in particular within consumer reporting space, really around medical debt. So there's been a lot of emphasis of late of potential consideration for removing medical debt reporting to, as a means to impact a consumer's credit bureau report. So a lot of emphasis there. And we've also seen kind of the more traditional FCRA type enforcement related actions at organizations. Also, we've seen a lot of activity around technology. So from a consumer compliance perspective, we're seeing that federal regulatory agencies, including the Consumer Financial Protection Bureau, are really taking a keen interest in the application of advanced technologies when applied to the delivery of consumer financial products and services. So things like AI, ML, natural language processing. And we're seeing a really increased emphasis in that within the context of not only just technology risk management as a whole, but how those are integrated within your compliance management system and your compliance risk management capabilities. We're also hearing from a number of clients and those in the industry of additional inquiries being made in the AI space and technology space, where regulatory bodies are really getting more focused on understanding how organizations are effectively managing the technology risks, especially as it relates to technologies that are leveraged and relied upon to achieve compliance with federal consumer financial law. I think a last comment in that space is where we maybe originally saw a lot of focus on the context of AI and the fair lending and kind of underwriting concept. We're seeing that really be applied at a more broader scale when the Bureau and other regulatory bodies are really taking a keen interest in how AI is being used beyond kind of fair lending type of application when we think about customer interaction, when we think about marketing and all of those things. And then finally, just one of the big things that we continue to see just a lot of focus on and things regulatory action is in, again, the BSA AML space, but specifically banks' ability to have effective KYC requirements and manage the third-party relationships that they have that impact that we'll talk about a little later.
Thanks, Joaquin. Yeah, I certainly think that's helpful. And it seems like fees have been, at least from my perspective, just an evergreen kind of theme for the CFPB. And it was interesting to see the FTC really join the fray on that this year as well. And certainly, from an AI and ML perspective, just to your point, many of our clients have shared that they're getting increasing reach outs and inquiries from the CFPB on that topic. So appreciate those perspectives. Kimberly, you spend a lot of time in this space as well. What are your perspectives? How do your priorities or kind of experience compare and contrast with what Joaquin shared?
Thanks, Tom. I'll add appraisal bias to the list. And then I'd also like to echo Joaquin's comments on advanced technologies, but more specifically to the need to be developing policies surrounding the use of AI. So with regard to appraisal bias, I don't know if this is an emerging topic so much as one that's been simmering over the last few years. There have been a lot of headlines around this, going back to when Biden launched his task force in 2021 on property appraisals and valuation equity. But then fast forward to this year, we've seen a smattering of activity in the way of guidance and rulemaking. The FFIEC has issued 2 pieces of guidance. First, its statement on exam principles for inspecting valuation discrimination and bias, which was early in 2024. And then this summer, it was followed by interagency guidance on reconsiderations of value for residential real estate. We also saw HUD release a mortgagee letter this summer mandating lenders to enable borrower-requested home appraisal reviews. And then the joint agencies, and this includes CFPB, FRB, OCC, FDIC, NCUA, and FHFA, issued the final rule on quality control standards for automated valuation models. And notably, this was a rule mandated by the Dodd-Frank Act in 2010, so it's been pending for a while. This rule is going to take effect in October of 2025, and I did want to mention that CFPB has issued a small entity compliance guide earlier this month, which upon first glance could be really helpful to all institutions, regardless of your regulator, with figuring out applicability of the rule, whether you qualify as a mortgage originator or secondary marketer under the rule, whether a transaction qualifies based on being secured by a consumer's primary dwelling, and even whether a specific approach constitutes an AVM. Institutions engaged in mortgage lending should be familiar with these requirements and their associated recommendations across all of these releases and be making updates to first-line processes, CMS elements. And I also don't think it's too early for internal audit to be including appraisal bias and audit plans. So help set a baseline for where programs are today and encourage enhancements in alignment with these releases. And then going back to AI, I think this is going to obviously remain a frequent topic of conversation. I've had clients tell me that they aren't using AI and ask why they need a policy. And by AI, I think what they've really meant is that they aren't incorporating generative AI into their direct activities. Nevertheless, it's important to understand what current activity looks like, document what your institution's stance is now so that future usage can then evolve in line with your risk appetite. And even if you're not using generative AI, there may be other types of AI in use. So think natural language processing and chatbots. We talked about underwriting algorithms. Third-party partners could be using generative AI, and certainly employees are likely using it in some shape or form, even if it's just out of curiosity. I think it's really important to understand what that usage looks like today, make sure the policy contemplates all of the potential usage. And then once you have that documented policy, you can turn to considering use cases for where it may be appropriate to begin incorporating AI in the future.
Certainly a lot in there, Kimberly. I think that will continue to unfold in 2025, but that has been, and I think continues to be, just top of the radars for compliance professionals, regardless of industry, and how we provide the right oversight of that. We appreciate those perspectives and certainly helpful context. I think, from my standpoint, we focus a little bit on some of the supervisory priorities, but of course, there's probably no clearer indication of a regulatory priority than the enforcement activity that underpins it. At least in year to date, we've seen several high-profile enforcement actions that have highlighted new or emerging areas of focus. Josh, I'd like to turn to you for a moment, simply as somebody that's very closely attuned to the regulatory environment and enforcement trends. How would you characterize recent enforcement activity in the consumer compliance space? And are there any salient trends or areas of focus that have stood out to you in the past year?
Yeah, thanks so much, Tom, and great to be with y'all today, this morning or this afternoon, depending on where you are. I think one trend, and this is, we see this from the flurry of activity. There's a new enforcement action this morning, right? It's a very intense enforcement environment. The CFPB really has staffed up its hiring. I think they're fairly stretched. There's a lot of litigation going on, right? So it's not just settling cases and moving the enforcement team to the next matter. You got a lot of staff who may have otherwise been looking at, managing investigations or initiating investigations or actively litigating because institutions are not settling. So I think there's an intensity there that is maybe unique to the current situation. And the Bureau was pressed by a Fed OIG report to close or to kind of manage its investigations to a 2-year horizon. So I think there's pressure to either move things along or kind of conclude them, not let things hang out for a long time. We're also seeing intensity with respect to the positions the Bureau is taking, right? There's been a lot of talk about interesting circulars or rules that may be outside the scope of the statutory authority. We'll talk about those. But in the investigation context, we're seeing really unique, really interesting, aggressive positions that we're disagreeing with. And so that, I think, is why the Bureau is not backing down from novel interpretations. And so I think that's why we might be seeing more litigation as opposed to increasing settlements. So that's kind of one just atmospheric feeling that we're seeing. From a substance perspective, a lot of interesting points on the supervisory aspects of fair lending, appraisal bias, non-discrimination, but really outside of redlining, we've not seen, particularly from the CFPB, the flurry of enforcement actions on fair lending issues. To appraisal bias, Rocket was just sued. That stemmed from a HUD complaint, the HUD investigation. It's not a CFPB investigation. So, fair lending cases are really complicated, particularly the statistical underwriting cases, the statistical pricing cases. So I think certainly a critical topic, and there's a lot of statements about how to manage emerging technologies. But I think it's interesting to note that there's been a lack, I'd say, of public enforcement actions, and maybe it's not for lack of trying, but a lack of public enforcement actions around kind of traditional fair lending issues in underwriting and pricing. And the other piece of that is UDAP is just a lot easier than fair lending, right? It's a lot easier to say, it's a lot squishier to say this is an unfair practice, this is a deceptive practice, this is abusive practice. So I think to some extent that's a nice shortcut. Why have a battle of statisticians when you can rely on your UDAP authority? So we're really seeing UDAP is the number one weapon of choice. And just finally, I think particularly for the banks in the room, I think we're seeing mortgage and deposit, really traditional, I'd say, mortgage and deposit enforcement actions. On the mortgage side, the flip in the market, right? We're in a purchase market. It's a a tough market. The volume is significantly down, or maybe coming back a little bit, certainly not where it was during the pandemic. And so when you see fighting for volume, you see aggressive approaches on LO comp, on RESPA compliance. And so I think there are a lot of interesting issues that may have been sleeping for a number of years that are coming back to the fore in the mortgage space. So that's kind of where I'll let it sit.
All very helpful, Josh. I would echo your points on UDAP in particular, and that's one that I think, kind of, as we pivot a little bit later in the conversation to some of how kind of the potential change in directorship at the CFPB, and certainly the change in the U.S. administration may impact the regulatory landscape. UDAP's been one of those that, to your point, can be used very broadly as just a tool to enforce acts or practices that CFPB doesn't like, and then conversely, under other directors and other administrations, is used to a lesser degree and more narrowly, and they look more to kind of the true letter of the law. So I think that'll be an interesting one to explore as we think about 2025 as well. All right, perfect. So with that, I'd like to move on to one more polling question for our audience. So our question to the audience: which best describes how uncertainty regarding the regulatory landscape has impacted your own institution's efforts to prepare for proposed or pending laws and regulations on the horizon? So our options range from no impact, we're moving ahead, full steam, some impact, we're continuing to prepare, with reduced urgency, significantly, we've paused readiness efforts or deferred key milestones and activities, and then lastly, not applicable to my institution. I'd say, at least anecdotally, there's a lot of it depends kind of in there from our client base, and we'll talk about the CFPB's open banking rule in a moment, but so many organizations that were smaller in asset size were kind of taking an approach of wait to see versus being forced to take ground on implementing some of those requirements given what may have been really fast implementation dates. But I think there's a lot that our clients have shared they're uncertain about going into 2025 with so many factors up in the air. Not only some of the judicial considerations, but also potential changes at the heads of the financial regulators and what that may mean for new laws and regulations that are pending, as well as those that may yet to be published. Okay, so I think we have about 60% submitted. Thanks everyone from your responses. Let's take a look at what you share here. So it looks like the vast majority of you say some impact, continuing to prepare, but with reduced urgency. And I think that's generally in line with what we've heard across the industry as well. I think, in general, as we look ahead at different regulatory requirements, there are some that have been kind of held up in the courts, and we'll speak to some of those. Some that have very rapid implementation dates where there is no room to defer or delay. So it sounds like at least 20% of the respondents here may be in that boat, forced to take ground on what you can while we're waiting, and regardless of what 2025 may hold. And then many of you falling into the some impact, continue to prepare, but with reduced urgency. So very helpful. Appreciate the responses as always, and think that's a good segue into what will be our kind of next set of questions and topics. So we spent the first portion of our discussion today focused more so on what can we learn from 2024 to date? Where are some of the shifting areas in supervisory scrutiny and enforcement activity? If we pivot for a moment to today, what are the current hot topics in consumer compliance? We'll do a bit of a round robin across a few that we know are relevant and certainly top of mind for the regulatory agencies and many of our clients alike. The first is, Joaquin, a question that I'll pose to you. So one area that we've seen an increase in scrutiny in recently is the concept of banking as a service. Can you share with the audience a bit about what that means and where we've seen scrutiny of banking as a service and what financial institutions should keep top of mind related to this?
Yeah, sure. Thanks, Tom. So we've definitely seen an increased level of scrutiny for banking as a service providers. at the both federal and state level. We saw this come to fruition further last year with the interagency guidance that was provided regarding third-party risk management that had a lot more kind of requirements and expectations around arrangements with fintechs and other types of third parties for which financial institutions are engaged in these partnership arrangements, and what that means in terms of heightened requirements for third-party risk management and oversight capabilities. A lot of this is really attributed to what I would call about 5 different kind of buckets of things. One of them is just generally regulatory compliance. So when we think about banking as a service for organizations that may not have otherwise been under the direct supervision authority of one or more of the federal regulatory bodies, what does that mean for regulatory compliance? The regulators have really been keen on ensuring that the banking as a service providers adhere to existing banking regulations, and has really tried to kind of catch up and discover the most effective way to effectively supervise banking as a service providers and the relationships that are held with bank partners. There's concerns around whether non-bank entities offering these financial services through banking as a service capabilities are complying with things like, AML, KYC, other consumer compliance requirements in terms of, the types of products and services that are being provided, or even whether it just involves customer data. We also really focused on consumer protection. So another major area of concern has been consumer protection, as you would expect. With more non-banking entities entering the financial services space, there's an increased risk of consumers being subjected to predatory practices or inadequate customer service standards, just given that some of these banking as a service providers may not have the level of rigor or focus in terms of risk management, consumer compliance, et cetera. And to the extent that that's involved in the delivery of that product and service is through a partnership with a bank partner, the level of oversight that's provided from the bank to these providers to ensure that, they are in adherence and in compliance with regulatory expectations. There's also some focus within the context of banking as a service on potential impact to overall financial stability. So really just understanding more in depth the relationships and the operating model for these providers, just to ensure that, there's a level of assurance and understanding of potential impact to the broader financial stability of not only the organizations, but the broader marketplace. Again, we've talked about it a little bit, but within the context of banking as a service, fair lending continues to be in mind to the extent that these providers and these arrangements, involve the delivery of loans that, we would have to have additional kind of emphasis on, the fair lending practices and compliance with those requirements. As we were talking a little bit about before, going back to the emerging technologies and the use of AI, it's really, the oversight mechanisms, the leveraging of AI for some of these products and services. And what does that mean in some of these arrangements, and what type of oversight and communication is happening to ensure that, it's well understood and there's traceability with the types of tools that are being used. And then I think, one of the things that threads this all through is just the continued focus on consumer privacy and security. And what does that mean in terms of enhanced and heightened security requirements that are needed to be able to achieve, not only the privacy, but also just the continued compliance across the broader gamut of consumer financial products and services. So I think that, those are some of the more hot button kind of topics and areas of concern and emphasis for the regulatory bodies as it relates to banking as a service. And what we're seeing from a more activity perspective from the regulatory bodies is continued issuance of, public comments, guidance. We're seeing things, comments from, not only leadership from the organizations, but also from a federal and state and interagency levels, just kind of communicating the expectations. We're seeing a lot more direct examinations of these types of bank as a service providers and fintechs. So, the regulatory bodies and CFPB is going directly into some of these larger fintech organizations and really applying the same types of requirements that would otherwise be provided at your traditional retail bank, with the expectation that there's effective risk management, there's effective compliance programs in place. And I think this all comes together with what we've seen is an increase in overall enforcement activity in the space as well. And so with some of these, not only these arrangements, but also directly at some of these kind of fintech companies and banking as a service providers.
Agree with everything. Agree with everything you shared, Joaquin. I think this is only further underscored by what we've seen as a couple of prevalent or headline-worthy fintech bank failures of late. And so if there wasn't already a very keen interest on behalf of the regulatory agencies on this model and compliance risk management therein, and in particular, to your point on consumer protection, I think that's only going to increase as we look ahead into 2025 as well. So appreciate your commentary on that, and certainly think everything you've shared is helpful and relevant. Kimberly, I want to turn to you as we think about some of the proposed or pending regulatory changes on the horizon. You've spent a good chunk of your career in the fair and responsible banking space, in particular as the fair lending and CRA officer at a prior institution. Interested in your take on the CRA data modernization and kind of the long tail that that's had. Can you share with us a little bit about where that stands today and what financial institutions should be doing, if anything, in anticipation of the change?
Sure, Tom. To say that this rulemaking has had a long or winding tail, I think that's certainly not an understatement. And in my opinion, it's really unfortunate indeed what's happened with it, because CRA as an area of compliance is extremely collaborative. CRA officers across institutions are very willing to share ideas and things that work. And there's always been a good rapport with their regulators, talking about what they're trying to accomplish and getting some input into their programs. So I think that this was a rule that everybody wanted to see moved forward. And what's interesting about the CRA is that unlike other laws where you've got one regulation that implements the law, one agency that's responsible for the rulemaking, so like TILA and Reg Z, TISA, Reg DD, CRA actually directs each of the prudential regulators to write their regulations themselves. So each agency is responsible for its own set of regulations, and they're all codified separately. And I think this is what's enabled the OCC, going back a little history here, back in 2018 to release its AMPR by itself. We saw the Fed and the FDIC kind of get on board with that as far as the questions that were posed. And then we saw the Fed drop out, and then we saw the FDIC drop out, and that leaves the OCC went alone in its own rule, which then ultimately was rescinded after an administration change. And for a time created a scenario where the requirements were not in sync across the industry. And for OCC banks, it's meant that they've already had to prepare for a new rule and then unwind it. So then we see a new notice of proposed rulemaking that was a joint effort in 2022. We get to the point of finally having a joint final rule in October of 2023. Actually, I think it's a year ago tomorrow. It'll be a year since that was issued. And it was supposed to take effect in April of this year. But in the meantime, there's been a lawsuit that was filed challenging this particular rule, and a federal judge granted an injunction in March that paused the rule altogether. So any implementation dates are going to effectively be delayed by the length of time the injunction is in place. And I do want to mention that the injunction in this case was granted more so based on the arguments with regard to the CRA rulemaking itself, the substance of it, as opposed to other cases that may be based on questions around CFPB's constitutionality. So that's a little bit different, and I'm going to talk about that one in a minute. But nevertheless, I think my view on this is really, given the windy path on this, that nothing's really going to happen until it starts to play out in court. And I think that said, there's still some things that institutions can think about in terms of how the rulemaking could inform activities under the current exam structure, because we do still have existing requirements for CRA. I think when you look at the new rule, it was very, very data collection heavy. I've seen current programs that have underinvested in tools to analyze their the sufficiency of their performance. So institutions could be thinking about any technical debt in the CRA space that could be a roadblock to setting up new data collection processes, or just generally that are impeding current analysis activities. So it's a good time to think about how to shore those up. I also think that you could look at what new data points were proposed to be collected, and maybe the service test is a good space to look at this, to where you could begin to build out your own data to support the existing requirements. So I'm thinking about understanding where your deposit base is located, where those customers are banking in terms of LMI areas and LMI borrowers. Do you have data that shows your penetration of alternative delivery usage by LMI customers? And then finally, just as a general rule, I can't underemphasize the need to have detailed policies and procedures in the CRA space. I've worked with several banks that have struggled following the departure of a key CRA resource. There's a lot of complexity involved in the exams, and when you lose that person who's managed everything on behalf of the bank, it can be a real surprise to find out that they haven't left behind a good roadmap for someone to pick up and continue to run the program successfully. So we've seen missed data submission filings. We've seen the inability to use data collection systems and tools by the team that's left behind. We've seen a lack of expertise in qualifying community development transactions. So really making sure that before the rules change, that you've shored up your existing program to better help you manage the change in the future.
It's a lot to think about, and certainly it's made more complicated by the start and stop and the scenario of the courts. And Kimberly, you hinted at this in your response, but CFPB's 1071 small business data collection rule have similar position, right? Can you talk to us a little bit about where that stands and what institutions should be thinking about there?
Sure. So Section 1071 similarly was subject to an injunction, and this is the small business data collection rule. And this rulemaking sat in a drawer for a while during the prior administration. And so we saw it reinvigorated with the change to the Biden administration. The rulemaking is promulgated. We see the injunction come into place, and it's only specific to certain institutions. It was later widened industry-wide. But ultimately, the injunction in this case, unlike in CRA, was tied to a different Supreme Court case regarding the constitutionality of the CFPB's funding structure. That other case was resolved in May of this year, and it did rule that the structure was constitutional. So with that, the injunction was lifted from the Section 1071 rulemaking, and CFPB has issued an interim rule that extends the compliance dates by the length of time of the injunction. So that was 290 days long. So what that means is, and there's tiers of lenders in this rule based on the volume of your small business applications. But for the largest volume lenders, they need to begin collecting data on their small business lending under this rule by July 18th, 2025. That's a Friday. Moderate volume lenders by January 16th, 2026, which is also a Friday. And then you get to the lowest volume, which is October 18th, 2026, and that's a Sunday. And originally these dates were the first of the month, but because of the length of time of the injunction, it's just created, I think in my mind, sort of weird, unusual implementation dates, we'll say.
Extra time to put the on over the weekend.
I know, right? Reporting requirements are still going to kick in by June 1st of the following year. So for high volume, it means reporting in 2026 versus moderate and small volume in 2027. And the interim rule does allow institutions to make a choice between whether you want to use 2022 or 2023 origination volumes to determine your initial compliance date, or if you want to look at 2023 and 2024. It also allows for early collection of the data. So you can get started to support your testing of procedures and systems. And CFPB has said that there'll be a grace period where it won't assess penalties for the first 12 months of collection, so long as you can demonstrate your bona fide efforts to comply. I think as far as challenges with this rule go, first, this is another major data collection activity. And depending on the size of the institution, this could fall in the same group that's already responsible for CRA data collection and or HMDA data collection. So that's a group that is often very tired at certain times of the year. I will say that tying this back to the modernized CRA rule, the new rule proposed for CRA had some allowance for institutions of a certain size to substitute the 1071 data collection for the CRA loan register data collection. And so with that rule on pause, it is an additional overlapping data collection. 1071 is focused on application data, not originated loans, which is the focus of the CRA loan register. So there's just a little bit of limbo in that until we know what happens with CRA. It carries a different timeline for submission than the other data collection requirements. So this one's coming in June rather than the March 1st timeline. And it's just creating, I think, confusion amongst institutions and how to weave this in to existing processes and leverage what you're already doing in that space. I think perhaps the biggest challenge is that all of the data that was required for this rule is not already being collected in the small business space. So there's a huge impact to first line processes to collect the data in the first place, and then update applications, LOS, core systems to be able to incorporate and store the data before you can even begin getting into the scrubbing of the data and submitting of the data. And then last but not least, I'll say keep in mind the lawsuit is still active. The injunction being lifted means that rulemaking can proceed, and institutions do need to be actively pursuing their plans to comply. But there's always still this potential that something could change based on the results of the lawsuit, based on the election perhaps as well. I don't think any institution should be hanging their hat on that, but I did want to mention it.
Kimberly, I'd say there's been a theme to all of your responses, and it's that data is paramount, which I think parlays nicely into my next question. So, with impeccable timing for our webinar today, the CFPB just issued its final personal financial data rights rule, which we often refer to as 1033, or the CFPB's open banking rule, which carries certainly some pretty significant implications for financial institutions. And we know that many of our clients have been eagerly or maybe even anxiously awaiting this final rule. Carries a lot in terms of operationalizing the requirements. Certainly a big piece of it relates to data sharing and data protection. So we're continuing your theme to a degree, Kimberly. Joaquin, I was wondering if you could share a little bit for our audience about kind of the nature and intent of the rule and what it requires.
Yeah, so the 1033 rule really focuses on empowering consumers just to have more rights over their own data in terms of the data that's being provided and with their financial institutions. The rule really requires that covered entities, which could be, banks and other financial service providers, to provide consumers with their personal data upon request. So it provides a legal framework to ensure that the customers and consumers have control over their ability to access their financial information and share that data with other financial institutions and authorized, third parties that they may want to engage with in a more seamless way. There's a number of requirements, but just to highlight some of the key requirements for the 1033 rule, it's again focused on customers' access to financial data. So it requires the entities, such as banks and other financial service providers, to make available to consumers upon their request transaction data and other personal financial information upon their request. So this is, intended to be able to provide transparency and giving, consumers more control over their data. Also, data sharing with authorized third parties is a key element of it. So the rule further extends requirements for data sharing, not only directly with consumers, but also with third parties authorized by the consumer. So this provision is really aimed at promoting competition among service providers. Another key element, which we'll talk about a little bit more in terms of may cause a lot of the most challenge here, is standardization of the data. So really to be able to facilitate the portability of the data for the consumer across, other providers at their discretion, it's going to require some standardization around data. So to facilitate that secure transfer and interoperability of consumer data across many types of financial service providers. So this is going to mandate that financial institutions adhere to standardized formats for data sharing. This again brings into security requirements when we think about the additional security that's going to be needed to be able to enable that interoperability and that sharing of data across financial institutions in a safe and secure way, really intended to mitigate some of the risks associated with potential fraud implications and compromising of customer data in that transfer of information across providers. Again, consumer privacy becomes a big component here as well, to ensure that we can effectively confirm and validate that we're authenticating the consumers in a manner before the data is provided and enable them to transfer it. And we have a level of assurance as organizations to make sure that the appropriate individual is getting access to only their data. And then again, I think one of the items here is compliance timelines, and I know many organizations were really heavily anticipating those timelines to come to fruition.
I think there was a collective sigh of relief that the effective dates had been extended in the final rule. So originally in the proposed rule, I want to say it was about 6 months for some of the largest financial institutions to implement this, which is very aggressive. So going back to that earlier polling question, how far along are you in kind of preparing for 2025, and to what extent has uncertainty impacted your progression efforts? This is one where some of the largest institutions just had no choice in the event that those dates weren't extended. But I think certainly collectively a welcome extension of those dates, with some of the smaller institutions now having all the way till I think 2030 to comply. But to your point, I think so much of this hinges really on data security. So much of the challenge today in sharing information across platforms stems from the screen scraping practices that are in place. And this is really intended to promote consumers' ability to move from one product to another with kind of as few and minimal obstacles as possible. And it's been interesting to see from my perspective, Joaquin, that the US is a bit of a laggard on this one. The UK, the EU, really globally, open banking initiatives have already taken root. So we're a little behind the curve on this one, but I think in terms of consumer protection, customer benefit, this is certainly going to help consumers. It's going to change the competitive playing field pretty significantly for banks. And there are going to be a lot of wrinkles in implementation that, as institutions digest the final rule, they'll have to consider. Okay. I think mindful of time, I'm going to go ahead and move to our our final polling question here as we start to turn the page to look at some factors for 2025. So to our audience, which of the below factors do you expect to present the most significant challenge for financial services institutions in 2025? A, increased regulatory scrutiny or shifting supervisory priorities. B, new or changed laws and regulations. C, implications of the U.S. presidential election. Or D, other. Should put an E on there, all of the above. And I'm sure you would have selected that one if it was there. So we'll give you a moment to respond to this before we dive into really a discussion on across these topics and some of how we think 2025 and the regulatory landscape may evolve in consideration of that. Give you all just another 10 or 15 seconds to respond. Thanks to those that have. Okay. So if we look at our results here, vast majority of you, 57%, said increased regulatory scrutiny and shifting supervisory priorities. I think we're with you on that. On newer change laws and regulations, in particular with some of it being uncertain, some of the effective dates being pushed out, certainly makes sense that falls secondary to kind of the rulemaking by supervision and enforcement. And then implications of the U.S. presidential election. That's interesting. About equal in the survey responses here to newer change laws or regulations. So thanks for your participation. Those are certainly interesting responses. We'll pivot for a moment to looking ahead a bit and kind of how the compliance landscape may continue to change into 2025. I'd like to kind of first start by talking a bit about the Chevron deference doctrine. And Josh, this is an area I think that's near and dear to your heart. But obviously, the reversal of Chevron by the Supreme Court has some pretty significant implications that is rooted really in kind of the case law itself. I was hopeful that you could share a little bit about what the Chevron doctrine meant, how it's changed, and then what the implications are for financial institutions moving forward.
Yeah, happy to do that. So I think I'm guessing the people on today's call are kind of in the trenches, day-to-day compliance. And I think one of the unintended impacts of the headlines from the summer was, maybe executives were saying, hey, Loper-Bright came down, the death of the administrative state, are we kind of free to challenge? And do we really have to comply with these, interpretations we don't agree with? And I think for those of us fighting the day-to-day fight, that's not the case. There's actually a lot more that goes into it. So kind of just briefly, Chevron, which is a 1984 case, that just said, look, if the statute passed by Congress, the first question is it ambiguous? And if the statute is clear, then the agency is tied to a strict implementation of the statutory language. If it's ambiguous, the court said, look, the agencies are the experts. We will defer to their kind of filling of the gap in the statutory language. And so if the court would show deference to the agency's interpretation. What Loper-Bright kind of restored was kind of a less deferential approach from the courts. And so although not completely getting rid of, courts looking at the agency's articulation of the policy reasons and the support for their position, there's certainly a shift in terms of saying, well, if the agency said it, it must be so. So that's kind of the big picture piece. I think what my concern is that, first, a lot of the challenges we're seeing, given the breadth of particularly the CFPB issuances, these are just, it's not about whether the statute is ambiguous. It's just, is the statute authorizing this in the first place? So for instance, 1033 rule, same day, lawsuit comes out challenging the rule. Kind of briefly, the rule is about giving access to consumers, and the lawsuit is saying, hey, the rule you created actually is about giving access to consumers and then all of these other institutions. And so is that too broad of a reading of the plain language? And so I'm not sure that's really a Loper-Bright issue as much as it is hey, you didn't have authority to go off and create this huge regulatory artifice under this small paragraph in the law. So we're seeing those types of challenges in general, irrespective of the administrative state. I think the other piece is to get, as an individual institution to challenge an interpretation, you got to get to litigation. And nobody wants to get to litigation. You got to go through supervision. You got to go through the investigation process, and then you can kind of argue it. So maybe, at the end state of an investigation, government may back off a little bit if they're pushing an interpretation of the law that may be aggressive. Reg X, mortgage servicing rules, is kind of an issue there. But I would say that, from a supervision perspective, the examiners aren't saying, well, our hands are tied by Loper-Bright, so we're going to, not implement, for instance, a circular that the CFPB came out with. So I think we don't want to overstate the issue, but it will definitely think lead to more challenges of regulations and other supervisory issues in the future.
I tend to agree. Certainly helpful context, Josh, and I think you put it well. So many of us are kind of in the trenches in many ways. This adds a whole new dimension of what we have to monitor and consider as we're evaluating regulatory change and readiness. Appreciate those thoughts and perspectives. Mindful of time, we'll move on to really our final topic, and this one's focused on the U.S. presidential election. I'd say if there's one thing we're certain of, it's that no matter what happens in November, we're going to have a new leader in the form of a new president come January, and with that, a potential change to regulatory leadership. I'd like to start, Joaquin, with kind of a question to you for our audience. Just what can we take away from past elections in terms of how significantly the regulatory landscape can change? How quickly does this happen? And does a change in the administration really move the needle in terms of consumer compliance enforcement?
Yeah. And to that end, I had the benefit of being at the Bureau during kind of that first transition when it was going from the Richard Cordray era to the Kathy Kreninger, so Obama to Trump. And what we can expect, I think now what we're seeing is that there's probably going to be maybe what I would say a little less impact. The last couple of cycles of this would be the Bureau's third kind of shift. There's a lot less around kind of constitutionality of the Bureau. I think that's already been settled. So I think the question of the Bureau's existence is no longer an element. And what we're going to see, what we would anticipate if there is a Trump administration versus a Harris administration is kind of two different paths in terms of emphasis on consumer compliance, where I think, in a Harris administration, we'll expect a lot of the same. So increasing the supervisory focus areas that we've already discussed today, that, at times kind of blur the lines in terms of explicit requirements that are under the authority of the Bureau versus a Trump administration that we would expect a quick shift in the directorship of the Bureau, probably I would expect within the first quarter, and then really not a deprioritization of consumer compliance, but really a more honed in focus on only those explicit requirements that are codified and clear in law, being focused on in terms of the strategic priorities. I think if there is a Trump administration, there will be some transition time in terms of identification of the new Bureau director, and then that director having the opportunity to come up with the appropriate, supervisory strategy. So those are just a couple of things that I think will have some impacts depending on the way the election goes.
I think that's helpful. And Joaquin and or Josh, maybe collectively on this one, but obviously, there are two different paths under the potential election. The answer may be relatively clear in terms of where consumer protection would take priority, but how do you expect or think that you'd see a change in terms of the level of enforcement or approach to examination as a result of one administration over the other?
Yeah, I guess maybe I'll offer two quick thoughts. I think one is, the supervision apparatus, they're embedded. Like, that's going to happen. I think maybe you get fewer referrals to enforcement, or as Joaquin said, kind of maybe more traditional enforcement. But maybe we see less aggressive interpretations of the law. I think the other thing to keep in mind is the UDAP statute of limitations is 3 years from the date of discovery. So if you're looking at a Trump administration that's only 4 years long, the next administration can look back once they discover the issue. And so even if we can breathe kind of an enforcement sigh of relief for a few years, you are absolutely still on the hook for any non-compliance that the next administration can reach back to get. So I think nobody's off the hook completely.
I think that's a helpful perspective. Fantastic. Well, mindful that we are approaching the end of the hour that we have reserved, I'd just like to thank the audience for your participation, and to our panelists, Kimberly, Josh, Joaquin, thank you all for the insightful discussion. We didn't get a chance for all of the questions, but we will follow up with those that have been submitted directly after the webinar. So thanks for submitting those. I'd like to encourage you to stay tuned for our next Value of Compliance webinar, which we'll be holding in December before the end of the year. And please check out the related resources in our resource window, which will also email to you separately a number of pieces of thought leadership and perspectives that relate to some of the topics that we discussed today. So with that, my thanks to everyone again. Have a wonderful rest of the day, and thanks for your participation. Be well.